turn it over to a big friend of the dialogues. I'm not even going to introduce her. She can come up and take care of that. And you all know who she is, but Milena, please come up. And Milena gets the very, very special job of introducing our speaker tonight. And we're very much looking forward to that. And so...
Thank you. Thank you, Jim. Good evening. My name is Milena Sterio, and I'm a professor of law at Cleveland State University and one of 6 permanent editors of the Int Law Girls blog. Int Law Girls is a legal blog open to female contributors and voices, dedicated to discussions of international law and policy. As most of you know, Int Law Girls was created by Professor Diane Marie Amen back in 2007. And according to Diane, she clicked a few buttons and mistakenly created a blog. I don't think it was a mistake, but this is what Diane told me. Int Law Girls has traditionally sponsored the Katherine B. Fite lecture at the International Humanitarian Law Dialogues. And if Katherine Fite were alive today, I'm certain that she would have been thrilled to contribute to our blog. For those of you who might not know much about Katherine Fite, she was an American lawyer who graduated from Yale Law School in 1930, but she was one of only 3 women in the entire country to graduate from law school. So think about that, one of just 3 women in the United States to graduate from law school. She went on to work at the State Department, and most famously, she worked with Justice Jackson while he served as chief prosecutor at the Nuremberg Tribunal. Katherine Fite is an inspiration to most of my female colleagues, and on behalf of Int Law Girls, it is my pleasure to introduce Judge Christine van den Wyngaert as the Katherine B. Fite lecturer tonight. Christine van den Wyngaert is a baroness and a judge on the International Criminal Court, currently in the Appeals Division. She obtained her law degree as well as a PhD in International Criminal Law from Brussels University. She was a professor of law at the University of Antwerp from 1985 until 2005, where she taught various criminal law subjects, and she also visited and taught at other universities, including the University of Cambridge and the University of Stellenbosch in South Africa. She's the recipient of several honorary degrees and has expertise working with various governmental organizations as well as with the European Union. Prior to her appointment at the International Criminal Court in 2009, Judge van den Wyngaert served as an ad hoc judge on the International Court of Justice, as well as a judge at the International Criminal Tribunal for the former Yugoslavia. For all of her accomplishments as an academic and as an international judge, the King of Belgium granted Christine van den Wyngaert the title of Baroness. And apparently she has a lovely coat of arms that I wish we could show here tonight. Without further ado, it is my pleasure to welcome ICC Judge Christine van den Wyngaert.
Thank you so much for this very warm welcome. I'm very happy to be here. I had heard so much about these Chautauqua talks. It was my friend Leila who had told me about it, so I had hoped to be invited at some point in time, and not being a prosecutor, this was not the obvious thing. So I'm very happy that International Law Girls discovered me and invited me to give this very prestigious lecture in honor of a very prestigious person whom I didn't know, I must say, but I discovered through the readings of Diane Marie Aman. I see her on this picture of the first lawyers going to Nuremberg, finding their way in the court building, and it's the only person in a skirt. Imagine if she would see us today, she would be so happy. So many academics here in academia, so many women who are doing their thing, who are very important in the academic world. She would also be happy to look at the judicial world, especially the ICC now, where there is this quotum for gender quotum. So we have at this point in time, 1 out of 3 judges is a woman. If you look at the presidency of the court, there's 3 women: the president, first vice president, second vice president. If you look at The Hague, you would find that in 3 courts you would have female presidents. You have Judge Brenda Filova, you have Judge Fernandez, and you have Judge Erlitzka from the STL. You would also note that Judge Winter is the president of the residual mechanism for Sierra Leone. So this is really a big change. You would also find that in the ICTY, in the ICTR, you had prominent female judges who were determining about jurisprudence in gender rights. I'm thinking of Akayeshu, Judge Pile, Navi Pile, who was presiding judge there. I'm thinking of Judge Mumba in the ICTY, who was presiding over Furunzia. So the female factor in international criminal justice has become important. Also on the prosecution level, of course, Fatou Bensouda, we are very proud of having her. We are very proud of having had Louise Arbour. We are very proud of having had Carla Del Ponte. So this is really a trend which I think is very positive. So if Katherine Fite would come back today, she would be happy about that. Would she be happy about international criminal justice? Of course, this is another point. Looking at today, the atmosphere was not so optimistic. We had talks that brought us down to reality. Of course, there's this general trend, anti-globalism, this new wind blowing in a different direction, states looking at the international community, not like a community with common interests, but as a kind of an arena where states are competing to have the greatest possible advantage. So this is a change that we are all feeling also in the field that we are working in today. But I don't think we should exaggerate. I think there is a lot of criticism about what we can do in international criminal justice, but it also means that we should do a reality check about what we can do. And I think the discussions that we have had today and yesterday are a clear illustration about what that could possibly mean. So I was thinking about what I could talk about today, which is not so easy for an audience that knows everything about international criminal justice. So I was inspired by the topic of Jennifer Trahan, who unfortunately has to speak tomorrow at an impossible hour at 8 o'clock. So I'm speaking after dinner, which is possibly to be compared. So she's looking at the future, international justice, criminal justice 20 years from now. I'm looking back because I'm having this privilege of having served in this world since, well, more than 17 years. And so I'm looking back at my own steps in that world, looking back at what I expected to find and what my reality check was at the end of all these stages in my judicial career. So I'm going to take you to first the ICJ, second the ICTY, third the ICC. So I started at the ICJ back in 2000, long time ago, the halcyon years of international criminal justice. The ICTY started functioning, the Pinochet had been arrested, we had these states having universal jurisdiction statutes, including my own country, Belgium, Spain, and some others. We had arrest warrants being issued. Oh, I must make sure not to stand in front of these. So this was a very interesting time. We were all waving on this very positive wave of international criminal justice. And then comes this first case before the International Court of Justice, really the very first important international criminal law case before that court. And I had this privilege to be appointed by my country as an ad hoc judge in the case of the Congo versus Belgium, the famous Yerolia case. And this was precisely about Belgium applying this very ambitious universal jurisdiction statute in a case against a Congolese national minister, incumbent minister of foreign affairs, for crimes against humanity and war crimes. And so I was there, going to this Valhalla of judges. For me, I was a young academic then, to be able to sit next to Judge Bergenthal, Judge Higgins, Judge Koymans, Judge Bejawi, the Japanese Oda, who had been there since 27 years. This was really a very important thing for me, as you can imagine. But unfortunately, I didn't manage to convince my colleague judges to the idea that we in academia were thriving on, namely universal jurisdiction was something that was in accordance with public international law, and perhaps more daringly also the point of immunities. Not going to go into the details of the judgment, I'm sure everybody is aware of what the decision was. The court didn't even look at universal jurisdiction. It was too divided on the issue. So the judges decided not to address it and only to address immunities. And actually, that's not so different from the first important case of the Permanent Court of International Justice, the famous Lotus case. Also then, the judges were very divided on the issue of jurisdiction, and it was only the casting vote of the president that made them tilt in one direction. And so on immunities, as we all know, the court decided that a minister of foreign affairs has no immunity from jurisdiction, even if he is prosecuted for an international core crime. That was the crust of the decision. Well, this was for me perhaps a first reality check in my ambitions that I had for international criminal justice. I sort of perhaps naively hoped that the judges could have been going in another direction, and ever since they haven't done, because sometimes dissenting opinions are a prediction of what is going to happen in the future, but not here, because as we all know, there have been other cases before the ICJ that have confirmed this position. It's a question that is still haunting international criminal justice, because if you want to go for the highest responsible, quite obviously you run into problems of immunity, certainly at the horizontal level. At the vertical level, in the ICC, of course, we have Article 27 of the statute, and we have tried to apply it. And again, there, in the practical application of it, there's no question that the ICC statute allows prosecutions of heads of state of member states, but to do it in practice, I don't have to make a drawing explaining it further. It has been very difficult to do it, and this may also be a reality check on the discrepancy between what is possible legally and what is possible judicially in the practical terms in the world in which we are living. So this was my first experience as a judge in the ICJ. Maybe I should, for the purposes of this lecture, make this little gender note about it. When I arrived at the court, this was in October 2000, I was the second female judge ever at a court. Rosalind Higgins had already been elected. She was really the very first judge there. And there was something sartorial about it, because I arrived in a lady's suit, you know, not with a shirt or a man's shirt, and the robe of the judges didn't suit me because it didn't work. And so, thank God, Rosalind Higgins had anticipated on that, and she had brought this little collar to put underneath, because the robe was just made for a male typical suit. Gender parenthesis. So my next step then was to be elected as an ad hoc judge, ad litem judge at the ICTY. I was in two minds about this, because of course, being an international criminal lawyer, I had been working academically on this. I was a professor since many years of criminal law, criminal procedure, but my hobby, my main academic interest had always been international criminal law. So to see this court in place, I was interested just to have a taste of it, but not really to go for a mandate as a permanent judge. And so I was elected as an litem judge, and I was called by Ted Miron, who was then presiding, to serve as a judge. And I had told him that I wasn't really interested in a long case because I didn't want to be away for too long from my university. And I must confess, I also had this little fear of being stuck in a court with 3 judges with whom you have to live for a long time. So I said, well, a short case will do. And Ted Miron assigned me to a case, the Wyngaert case, which was going to be a very short case, but eventually took a longer time. So joining this court, the ICTY, was a wonderful thing. This was in the year 2003. The court was running well. The first decisions had been made. There was this huge positive judicial culture to be part of. So it was a wonderful experience to go there. And quite soon I realized the difference between an academic job and a judicial job. It's something that Miron has very well expressed in an article where he says, well, when you go from academia to being a judge, you leave the comfort, the luxury of the academic study, the time for reflection, the ability to have 2 opinions at the same time. As a judge, you have to judge. And an international judge has the agony of having, on a very time-limited base, to decide about guilt and innocence of people of the most serious international crimes. So this is a huge responsibility that I felt was very different from what I had had as an academic. And of course, you are like national judges. You are sitting in trials, you are hearing the evidence, you are deliberating, you are writing judgments. So all of that is not so different from a national judge. Also, the importance of your judicial independence, your impartiality, fair trial rights, putting at the center of what you have to do. All that is not so different, but what is different is that the body of law that you have to apply is so new. There's no doctrine longer than 10 or 15 years. At the ICTY, I had a colleague, Judge Ori, who is now the last judge presiding over the Mladic case, and he had been a judge at the Dutch Supreme Court. And he was telling us that when at the Dutch Supreme Court they had a difficult legal issue, the judges would be in agreement for about 90 to 95% of the issue in terms of sources of law, jurisprudence, case law. Whereas at the ICTY, he said it was the other way around, because you had judges from different legal cultures, and also the law to apply it was so new, so full of unresolved questions. And that's something that I have experienced very much, perhaps even more so at the ICC, because at the ICC you have the treaty, so you don't have to dig into customary international law, but then there's so many constructive ambiguities in the treaty that the states couldn't resolve, that they just threw at the judges and they said, well, it's up to the judges. And unsurprisingly, you would find the same differences in opinion on many of these issues amongst the judges. So this was very interesting. It was a wonderful experience, but it's also daunting, because at some point in time you have to reach an agreement, and you may have situations where you have judges going in 3 different directions, which is of course appalling. And one of the examples I could quote from the ICC is the decision on the no case to answer / mistrial in the Kenya cases. So when the Kenyatta case, or the Ruto case, I'm sorry, came to an end after the prosecution case, the judges were divided. One judge wanted to continue, 2 other judges wanted to stop, but for different reasons. So if you read the judgment, it's quite strange, because you have one or two paragraphs, disposition, we're going to stop. And then you've got two reasonings of two judges who have totally different reasons to reach the same conclusion. And so this is, I suppose, part and parcel of international criminal justice. It's part of the thrilling aspect as well, because you are there and you are really called upon to interpret all these new rules and procedures for the very first time. So for me, this was a great experience, and I'm very grateful to have been given the opportunity to do that. I was going to stay just for a short time, but then I enjoyed it so much. I ended in a bench, a wonderful bench with an Australian presiding judge and a Swedish judge, and I was quite quickly converted into the common law. Because as a civil lawyer, looking at the ICTY from the outside, I was saying, well, you know, it's going to so slowly. I was of the belief of many civil lawyers thinking that if you would put in more civil law, that things could go much more efficiently, speedily. But I was very soon aware and convinced of the contrary. I won't expand on that. If you want, we can do it in the Q&A. And so in my 6 years there, I had the privilege of sitting in 6 trials. I did Strugard, the very first case on cultural property. Al-Mahdi is the second, Strugard was the first. I did the Merxis case about Vukovar. I did Limay, the Limay case, which is already for me a sort of a foreshadowing of my next mandate, because my next mandate will be a judge at the Kosovo Specialist Chambers, and I've learned a lot from how that case went, and I'm quite concerned and quite skeptical about what will be the situation at the Kosovo Specialist Chambers, because what I fear, I hope it's not going to happen, but what I fear is that exactly the same kind of problems that we saw there will again appear before the Specialist Chambers. But all this being said, it was a privilege to be at the ICTY. The only negative point, and again, I'm making reality checks on each of my mandates that I'm now describing to you. For me, the most disheartening thing is that the ICTY, it has been described at length this morning by Kevin, that the ICTY did not manage to create a common narrative for the former Yugoslavia. When I went there, one of my probably naive ideas was that I was now going to contribute to the writing of the history of the former Yugoslavia, or what happened in the conflict. I didn't have the ambition to really, this historian, very broad truth-finding ambition I don't share, but I had hoped that the mere fact-finding parts of it would be accepted in the region. I was hoping that for some time the ICTY was taking the hot potato away from the region until they would be strong enough to stand on their feet and take it over. And of course that was sheer naivety, and it didn't turn out. And that's what has been described very aptly this morning by Kevin. And it's something that I find so sad, because the ICTY, if you look at the jurisprudence, there's not much more that a court of law can do. So if that doesn't work, how can we achieve one of these goals that we have, and that is to reconciliate, to have a narrative that is common to the region. From that perspective, I've been wondering whether the Truth and Reconciliation Commission formula is not better. You have been discussing that today, Valerie, about a specific Canadian issue, but thinking of South Africa, if you look at the TRC, they have produced a common narrative. The history books have now a common history. If you look at the former Yugoslavia, they still have their own different narratives, and the Croats are unhappy about when the ICTY convicted Croats. They're unhappy when the ICTY was too soft on the Serbs when Croats were victims, and the other way around. And then there's this denialism of the Serbs about Srebrenica. So to me, this is one of my big disappointments, and I have no clue. I couldn't think what the court could do to change that. And I refer to the writings of Milanovic, who identifies a number of points. For example, that if the elites in power don't change, then there's no way in which the narrative that is produced by an international tribunal is going to be accepted. And so that's one of my major concerns that I have for my next job at the Kosovo Specialist Chambers. If that is not going to happen, how is this jurisprudence going to be accepted by the population? So that's my ICTY time. And then in 2009, 2008, there was a call for nominations at the ICC, and my government asked me whether I would be willing to run. I said, well, I'm so happy at the ICTY, why should I go to the ICC? I knew from that side of town that at the other side of town things were perhaps not so easy, but then I said, well, why shouldn't I do this? Leila was one of the persons who said, why don't you do this? And indeed, it was again a new court, new challenges, fantastic actually to be allowed to be there. So I ran a very difficult campaign. By the way, these campaigns are so degrading, it's amazing, but you have to go through it. In my very first mandate, when I was an ad litem, I didn't even do the campaign because I found this beyond the judicial dignity, but that was only an ad litem job. For the permanent mandates, it's really a struggle, it's horrible. So I struggled, I won, and I went to the ICC, and it was a very different place, much more difficult than the ICTY. I soon realized what I had learned in literature, that the ICC is many courts in one. It's very difficult. What Yuval Shani calls goal ambiguity. There's so many different goals that it's difficult for a judge to render decisions that are accepted by the constituencies, because you have so many different constituencies. You have states, you have the NGOs, you have academics, all sorts. And so whatever you do, whatever you don't, you are criticized. I'm referring to this wonderful article by Darrell Robinson about the dyads. And that's exactly what I have felt in my own work at the court. For example, the court is a criminal law court, that's the basics. But still at the ICTY, the judges were more in sync about the basics. At the ICC, you would find judges who are more human rights oriented, more teleological in their approach to the law, and then you would have judges who are more black letterish like I was myself. But to give an example, in the Lubanga case, where, as it was said today, the charges were only conscription of child soldiers, not the sexual offenses, you would have Judge Odio Benito, judge of the Inter-American Court of Human Rights previously and actually, who had a much broader definition, and who said, well, these cases are not only about guilt or innocence, but also about the harm to victims, which is something I didn't agree with. And you would have these type of discussions which I had never had in my previous court. So it's a criminal law court, it's a human rights court to some extent, because well, the whole issue of victims' participation, but also we have to decide in questions of admissibility. I remember one of the cases when I was in the pre-trial division, it was about the admissibility of the case against not Saif al-Islam Gaddafi, but al-Senussi, where we decided that the Libya could proceed with the case, because on the statute books, they had the necessary human rights guarantees. We were very much criticized, because they said, well, the court should have looked at how these rules are applied in practice, which is also a fair position. So this was one of those decisions, you're damned if you do, you're damned if you don't. But I still stand by what this decision was, because in terms of admissibility, there should be deference to national jurisdictions, even in those circumstances. So the court, criminal court, human rights court, also a civil court, because dealing with reparations is something that is so new. It's very new. It hasn't been done before. And so we are trying to put into practice the noble ideals of this Declaration of 1995 on guidelines and principles on rights of reparation of victims, but the devil is in the details. How do you do it? And we're trying to do it, and we have had now the first decisions, very long due in the Katanga case, where the court has decided that each individual gets 250 euro. We have the Al-Mahdi case with this reparation decision, 2.7 million euro. And all those reparation decisions are theoretically addressed to the convicted person, but of course they don't have the money to pay, so everything goes to the trust fund. So one of the questions is, why perhaps shouldn't all these things go directly to the trust fund without passing through all the different procedural stages that get us there? So the ICC, many courts in one. I myself had the privilege of being in 3 different divisions. As you know, the mandates are 9 years, and so I had 3 years in the trial division, 3 years in the pre-trial, 3 years in appeals. So it was a wonderful experience, but very difficult, much more difficult than at the ICTY. Proceedings take much longer, they're much more complex, because the court has to decide about things that the ICTY wouldn't have on its plate, like admissibility decisions, for example. And then, of course, there's the victim participation, which is also an issue in its own right. So, for me, the ICC, my mandate comes to an end next year. It's a very challenging place, and I think we will have also to do a reality check about what the court can do. It has been said this morning, there's a problem of the resources. The prosecution can't go and investigate all situations because there's simply no money for it, and the states are not going to be prepared to do that. There's also an expectations on the victims. I have my own views on how the victims system should change and why I think it's not all right. I've done my Klatsky lecture on this a couple of years ago, so I won't repeat it here. But I think the least we should do is manage expectations, because the victims have so huge expectations, and we have to be more honest. We have to be more open in what we can achieve so that we don't create disappointment. So there's all these things that need to be done, but they can be done. It's not that they can't be done. It's not because we are aware of our own limitations that we are failing in our mandate. On the contrary, I would say we have to do this reality check. So let me end with a cliché question. Is this now the end of the beginning or the beginning of the end? Of course, it's the end of the beginning, because the ad hocs are closing down and the ICC is remaining. So that's certain. But then, I'm quoting David Lubin now, he says, well, the honeymoon is over. But yes, honeymoons go over after some time. There's some boredom, there's some financial constraints, there's tensions, there's expectations that are not met. Yeah, but it doesn't necessarily mean divorce. And so for me, the important thing is to look at it from a broader historical perspective. If you look at the ICC or International Criminal Justice now, from the perspective of the 1998, the enthusiasm, the treaty was there. These were the halcyon years of international criminal justice, when we had all sorts of expectations, also universal jurisdiction, immunities. So, well, yeah, these were times that we had in mind. But if we now compare ourselves to what we are doing just now in Belgium, my country, the commemoration of the First World War, 1418. If we compare ourselves to that point in time, Versailles, Articles 227, 228, the idea of prosecuting the Kaiser, but then it's not really, they didn't really mean it. Bill Shabazz is writing a fabulous book on it. I won't say too much, but what was in Versailles is nothing, not even a crime. They were going to prosecute him for a supreme offense against the morality of nations. They didn't even use the word crime, although it had been discussed, but there was no preparedness and states were simply not willing to go that road. Also for the prosecution of the German officers. For example, I myself, in my family, I have a victim in one of those Belgian cities that were attacked by the Germans when they came into the country. So I'm an indirect victim of what happened then. But also that, it was not serious, there was no idea of really bringing these people to justice. So that's 1918. And of course, Hitler then in 1939, just before invading Poland, said, who remembers about the Armenian genocide? And in 1945, we did things better. So we had pioneers like Jackson, like Whitney, like others who really had to create it from scratch. You know, the London Charter was created from scratch. This judicial architecture that we think is obvious now, of war crimes, crimes against humanity, genocide, crimes against peace, is something that was new. That people had to do it, had to fight for it, and this trial really was, in retrospect, something fantastic. So if you look at what we are having now, we are having a lot. But also, if you look at it from the perspective, I don't see students here today, from perspectives of the time when I was a student. Yes, we've got students here. When I had your age, there was no, in the 80s, I was amongst academics dreaming about an international criminal court. There was no question of us seeing this in our lifetime. Nuremberg was dead. There was no willingness whatsoever in the Security Council. So all of a sudden we had the ICTY, and all of a sudden there was even a court where I had the luck of functioning with a number of colleagues, academics who had been dreaming about the International Criminal Court in those days, like Judge Ori, Judge Drexel, Judge Schwartz, Judge Schomburg. We all found ourselves together in the ICTY, and we were given this opportunity to help developing this first jurisprudence. So if you compare what is happening today with the 80s even, things are not so bad. We have a court. We have had the ICTY, the Special Court of Sierra Leone. We have brought a number of dictators to justice. I don't have to name them all. We all know them. So this is a fantastic achievement. And even if we have a dip in this point in time, this should not take our convictions away and our enthusiasm about the project. I think it's very important, even more important today, in these days of alternative truth, fake news, to have judicial institutions that can establish the truth according to judicial procedures. And if we can't have it, let's at least have what David was explaining us today, commissions that act as a quasi-investigating, prosecuting organs to freeze the evidence and to make sure that at some point in time the evidence will be used. Pinochet didn't expect that at some point in time he was going to be caught, neither did Milosevic and Karadzic. So let's think of that. And let me just end this talk with a quote of Ben Ferencz. When he was in Washington accepting this honor that the Dutch government was doing to him, he was getting a street in The Hague with his name. And so he gave a very inspiring speech, as he always does. And at the end, and that's where I'm quoting him, he gave an advice to the younger generation. 3 points. 1, 2, 3. Don't give up. Don't give up. Don't give up. That was Ben Ferencz. Thank you for your attention.